Good morning, everybody, and welcome to this webinar, in fact, on Offers to Settle in Part 36. Now, at any time, Offers to Settle and Part 36 are important to consider throughout your litigation, but even more so now in times of coronavirus and COVID-19, and with court delays, you and your clients might be thinking more about what offers to settle you might like to make, and when in fact to make those. If I just share my screen with you, then a presentation should appear on your screens in a few moments, and we will work through this together. Now, offers to settle, as I'm sure you're all aware, is an important part of the CPR and the overriding objective, and you must consider throughout the course of your litigation, your client's litigation, in fact, what are offers to settle and settlement offers. And we all know that if you don't, there can be cost consequences that follow with that. Now, a big part of this webinar this morning will focus on Part 36, and that is because it's its own unique set of rules, and quite often as a barrister I get questions about Part 36 and the consequences of it. So I think it's an important area to just cover over and just have a recap about the rules and what's contained within it. Now, I'm always of the view when I get instructed on a case, I often ask, what is the appetite to settle? And I ask that both of the lay client instructing me and also on the other side. Now, some people think that's particularly strange, that as a barrister I'm saying, well, what's your appetite to settle this? And that's not because I think a claim is weak or that someone should make an offer to settle there and then, but offers to settle, as I'm sure you're all aware, are a very useful tactic in the litigation armoury. When are you going to make one? And if so, what form is it going to make? Most people on first blush, when they're asked about that, think that I'm concerned there's a weakness in the case and think making an offer might be seen as a weakness. Actually, sometimes it can put you in quite a strong position, depending on the time that you make that offer. Now, in my view, there are sort of a series of places throughout litigation where you might make such an offer. You might wait until after disclosure, so you can see what's going on both sides, what evidence they have and what evidence you have, and be able to weigh that up. You might wait until after witness statements, for example. Again, you can see what their witnesses are going to say, you can see what your witnesses are going to say, and you can stack that up. Or even, in fact, you might think, well, let's think about some offers after the precedent H's if you're in multi-track or high-value claims where precedent H's and cost management is required. You might think, well, actually, we've now seen the cost of litigation on both sides. That might focus both parties' minds, in fact, as to the cost of litigation, and offers might then be exchanged at that point. So it is important to consider all the way through whether you will make an offer to settle. Now, I'm going to kick off with without prejudice offers. Now, please note this is just without prejudice offers. So that is not focusing on anything that's without prejudice subject to costs, which we'll come on to shortly. The whole point of without prejudice correspondence historically has been to get the parties discussing matters freely and to discuss settlements. If you don't reference costs anywhere in your letter, then technically that correspondence cannot be put before the judge on the issue of costs. And that comes from the case of Walker and Wilshire. So any discretion that the courts have in respect of costs doesn't necessarily apply to without prejudice offers. If you do want the court to consider it without prejudice correspondence, then both parties must waive privilege over that document in order for it to be put before the court. Now, I say, is there a reference to costs? It might not say on the face of the document without prejudice subject to costs, but actually there might be a reference within the correspondence itself that the offer is made subject to these conditions on costs. The court will look to the substance, as we all know, with without prejudice correspondence. Just because something's headed without prejudice or headed in a particular way doesn't necessarily mean it has that effect. So just think, first and foremost, do I want the judge to look at this in respect of costs and exercise of discretion? If so, perhaps the easiest thing to do is make sure your heading is correct, without prejudice subject to costs. Or you can argue with the other side if for whatever reason you've omitted that heading. Well, actually, it's quite clear from the correspondence that we did intend there to be some relation to this in costs when the judge came to the question. Now, that position in without prejudice correspondence, the courts found unsatisfactory, and that's what gave rise to this, what we all know as Calderbank offers. So that is your without prejudice save as to costs offers. Now, the court has a discretion as to whether they take that correspondence into account, and that comes from CPR 44.2 subsection 4 subsection C. And it's entirely the court's discretion as to the amount they take any correspondence or offers to settle into account. Now, with Part 36, which we'll come on to and actually spend quite a large proportion of time focusing on this morning, the Calderbank offers and the court's discretion under CPR 44 is wide. The court doesn't just need to consider, has a party beaten an offer that's been put forward? It can consider things in terms of the behaviour, how the parties operated, has the litigation been pursued in a fair manner, and actually, was this without prejudice offer a genuine offer to settle? And they're all things that the court will consider. Just last week, or the week before, in fact, 22nd of May, the court, in the case of MEF and St George's Healthcare, gave a good overview of this topic, Calderbank offers and Part 36. Now, again, we'll come on to this very shortly in respect of Part 36 offers, but actually at times you need the court's permission to accept a Part 36 offer, and they can be limited or withdrawn at any point. In the case of MEF, what happened was it was a detailed assessment proceedings, and the Healthcare Trust had made an offer to settle. It was a without prejudice savers to costs offer. That offer was not time limited or withdrawn at all, and during the course of the detailed assessment, it became clear to the lawyers for MEF that they weren't going to beat that offer in the Calderbank offer. So what they did during the course of proceedings was actually accepted the Calderbank offer. And the Healthcare Trust argued that the MEF were prohibited from accepting that offer, and that it was reasonable to read into Calderbank offers that they were in fact withdrawn after a reasonable period. And the court said, on appeal, said, no, that's not the case at all. A Calderbank offer, you need to think about your terms and conditions as you would in a contract, and you can't imply into a Calderbank offer that it's withdrawn after a reasonable period if you don't specify that. So if you want to have the consequence as well that Calderbank offer couldn't be accepted when proceedings started, well, you should have specified that in your offer, and you didn't. And the court also made comments throughout that judgment in respect of, well, Part 36 was also open to you, so you could have chosen to make a Part 36 offer, but you didn't. You went with a Calderbank offer, and therefore you don't have the automatic sanctions of a Part 36, but instead the court now has its discretion in respect of costs under CPR 44. So this raises the question, really, why might you use a Calderbank offer over a Part 36? Well, the first thing to say is that a Part 36 might not be applicable. So, for example, in small claims, Part 36 doesn't apply as a result of CPR 27. But actually, again, that raises the question, actually, in a small claims, how much of your costs are you likely to recover anyway? But you might not want to comply with the rules in Part 36 because they are automatic and there are certain sanctions that follow. So you don't want to fall foul of the rules either, because you might not necessarily appreciate what the automatic sanctions will be, or your client might not want those sanctions to apply. So I have teased around the question of Part 36, which I think is an area of great importance in CPR and also some great confusion. So I think I will now move on to Part 36. There's some debate, some sort of journals around the subject, and one thing that I came across while I was researching for this webinar was many people call it a carrot and stick method, and that is the idea of these automatic sanctions, and if understood properly, then they can have a great consequence to either party. It is a self-contained set of rules, but you do need to consider the contractual elements when you're making or receiving an offer, and the court confirmed that in the recent case of Ho and Adedeken. Now, there are cost consequences which need to be considered, and when you are considering those cost consequences, sorry, that's a tongue twister at this time in the morning, then you'll need to look at which party made the offer, at what point was the offer made, was it made before or after proceedings were commenced, was it made more or less than 21 days before the start of trial, and that's important in terms of cost consequences, which we'll come on to shortly. Has the offer settled all or parts of the claim? And has it been accepted before or after the relevant period, which is a key definition, which I will talk about in a moment. And if it's ignored, what has happened at trial in respect of the judgment? Has there been a split trial? Are there multiple parties? Are there cases, is it in relation to a case where there are fixed costs? And is the offer made in respect of detailed assessment? I don't particularly intend to focus on those last four elements today, and some of those in any event are more akin to personal injury and relevant there, and there are particular sections of Part 36 that are relevant to personal injury claims. But as I say, understanding the definition of relevant period is key to many parts of the Part 36, and subsection 3 of Part 36 gives us some key definitions, and I have just picked out the relevant period because I think it's important that we understand this as we go through. So the relevant period is if the offer is made not less than 21 days before trial, a period that the offeror specifies, or for a period as the parties agree. So there may be an extension if you're seeking some clarification, which I'll come on to. If it's made less than 21 days before the start of trial, then the relevant period is up to the end of the trial. But there will be, in order to accept an offer once trial has started, it is highly likely that you're going to need permission of the court to accept that offer. There are also, with late offers, then some consequences that follow through in terms of costs, which we'll come on to very shortly. So what constitutes a valid Part 36 offer? Now, the key to a valid Part 36 offer is given to us in CPR 36.5. It must be in writing. It must make clear that the offer is made pursuant to Part 36. It must specify the period, so the relevant period there needs to be stated. Also state whether it relates to whole or part of the claim, and state whether it takes into account any counterclaim. If your offer is not compliant with Part 36.5, then the automatic cost sanctions will not apply, and the court will instead divert to its discretion under CPR 44, and that comes from the case of Shaw and Merthyr Tydfil County Borough in 2014. So it's important to make sure you comply with these requirements. Try and make your offer as clear as possible as well. What are the terms? What are you offering? And what are the conditions of acceptance? It could be something that's in monetary terms, or in fact, you could just be making an admission of liability in that Part 36. It doesn't have to be a monetary term offer. That in itself then has consequences in costs, as we will see shortly. Now, if you are wary of making a Part 36 offer on letterhead, or you want some guidance, then you can use Form N242A, and that is a prescribed form which gives the sections that need to be complied. It states, it indicates whether it's a claimant's offer, a defendant's offer, the relevant period, and then it asks you to set out the terms of your offer. So there is some guidance and there is some help in respect of formulating the Part 36 if that's the way you want to go. It is absolutely, as I say, fundamental that you specify what your relevant period is in your offer. It can be 21 days, and most people do go for the 21 days and say, well, they're the rules that the Part 36 require from me, but actually you can make it a longer period. So right now, for example, you might think you might be making your Part 36 offers. You might know from your opponent, actually they're having some difficulty with their client because certain employees or certain decision makers are furloughed or whatever. So we will extend that period beyond 21 days and we will allow 30 days or whatever you're comfortable with, really. As I say, if your offer is made less than 21 days before the start of trial, then paragraph 1C doesn't apply because there are other cost consequences that come into play. And then subsection 4, a Part 36 offer which offers to pay or offers to accept a sum of money will be inclusive of interest until the particular dates are specified. One thing that does crop up, and I've actually had a question prior to giving this webinar in respect of terms as to costs. Now, Part 36 is an automatic provision, and the cost consequences follow automatically. So you don't need, and in fact you shouldn't have, a term in your offer as to what happens with costs. And in fact there have been cases, a recent case of James and James in 2018, where the court have said, well, you've put a term in here about costs. That is completely against what Part 36 is about. The rules in respect of costs are clear on Part 36. You don't need to have that term in there. And in fact, in James and James, what they had done was put in a term on costs that was wholly void of any reasoning under Part 36 and actually went against what Part 36 was about. So the court decided in that case that isn't a valid Part 36 and deferred to its discretion under Part 44 when deciding the issue of costs. So you do need to be very careful what terms you put in there. And actually my strong advice would be completely avoid any reference to costs in your offer. The sanctions are automatic, it's not necessary, and it avoids confusion or in fact making your offer something other than a Part 36 offer. An important point to note if you're a defendant and you are making an offer, you must make an offer which is a sum in settlement of the claim, and it must be a single sum of money, so inclusive of interest, etc. And if that offer, you must be able to pay that offer no later than 14 days after the acceptance. As I said a few moments ago, it's important to make sure that your offer is as clear as possible. If you're in receipt of an offer and it's not clear, then CPR 36.8 gives you the ability to ask for clarification. That clarification must be done within 7 days of the receipt of the the offer. And if there's no response within 7 days, then you can make an application to the courts under CPR 23. It's useful to specify on that application if you already have a trial judge, for example, please don't let it be the trial judge unless the parties agree it should be. CPR 36, an offer may be withdrawn or amended provided that it's not been accepted. Any such withdrawal and amendment must be in writing. In accordance with 36.9, you can state in your Part 36 offer that actually, after the end of the relevant period, the offer will automatically be withdrawn. That must be made clear on the face of the offer. And if it's not, then it's not been taken to be withdrawn at the end of the relevant period. You must specify an automatic withdrawal. If you don't withdraw it, even if you've specified the relevant period as X date, if it's not withdrawn, then technically that offer remains open to acceptance. What will flow from the late acceptance of that offer is the cost consequences, which we will come on to in a moment. So just if you're making an offer, think about whether you want to automatically withdraw it, whether you want to let it lie on the table, and think about the benefits of each of those. If you do withdraw your offer, one consequence of that is actually you don't have the protection of the Part 36 costs. And again, the court will defer to its discretion under CPR 44. So actually, the best case might be to just let the offer lie there. Know it's there, know that it's not been accepted within the relevant period, and see what happens at trial in terms of judgment. If the offer is withdrawn or amended and the terms become less advantageous, then the offer is, if it's not been accepted, the withdrawal notice has the effect of the end of the relevant period. If it has been accepted and you've amended or withdrawn the offer, then actually you need the court's permission to withdraw the offer within 7 days of notice of acceptance. Situations where you might want to withdraw or make a less advantageous offer is where, for example, new facts come to light and you learn things that actually you think are better for your case now than at the time you made the offer. I am trying to whistle through the remaining sections, but we will run over the half an hour, which I do apologise for, but it is quite a meaty section, CPR 36. If you accept your offer, if you're accepting the offer that's been made to you, then your acceptance must be in writing. As I say, provided that the offer hasn't been withdrawn, then it can be accepted at any time. There are certain situations where you will actually need the court's permission to accept a Part 36 offer after the relevant period. Most of those relate to personal injury, but the one that is important for us to remember is that where the trial is underway, you are going to need the court's permission to accept the Part 36, or where there are multiple defendants and they haven't been sued jointly or in the alternative, or severally, in fact. So you will need the court's permission to accept in those situations. Right, this is the bit that we get the most questions on, and I will do my best to explain as clearly as possible. So if you accept a Part 36 offer, then CPR 3613, which is taken from the White Book and is on this slide here, then provided it's accepted within the relevant period, the claimant will be entitled to costs of the proceedings up to the date on which notice of acceptance was served. So that is regardless of whose offer it actually is. If the claimant accepts the defendant's offer in the relevant period, the general rule is that the cost order is deemed to be made on a standard basis, but the claimant is entitled to 100% of their costs after an assessment at detailed assessment if they cannot be agreed. You will see that it says subject to paragraphs 2 and 4 of this particular section, which I have on this slide here. So if the defendant's Part 36 offer relates to only part of the claim, and at the time of serving notice of acceptance, again within the relevant period, the claimant abandons the balance of the claim, the claimant is then only entitled to the costs of the part that they've accepted, unless the court orders otherwise. So you could have some debate there as to whether you should be entitled to everything, but actually I think, and the case law suggests that the fairest position is that the court will say, well, actually, you've abandoned the rest of your claim, and if those costs can be so distinguished from the part that you've accepted, why should you be entitled to those costs, and are most likely not to award them. But there is some difficulty in assessing that, because actually, how can you distinguish what each element of the costs has been in relation to, unless you've got very, very clear time recordings on your time management system that says time engaged considering element A of the claim or element B of the claim? I can't see how you're going to be able to distinguish what costs relate to what aspect of the claim, really. And for example, witness statements, if you get to that point, are you going to be able to apportion a percentage of that time to say, well, that element of the time was spent on this part of the claim? I don't know. And it's a fiddly exercise to do. So it is a difficult one, really. And paragraph 4, where a Part 36 offer, which was made less than 21 days before the start of trial, is accepted, or is accepted in relation to the whole of the claim after the expiry of the relevant period, the liability of costs must be determined by the court unless the parties have agreed the costs. And what the court looks at there is in subsection 5. What the normal rules are that the claimant will be awarded the costs up to the date the relevant period expired, and the offeree will pay the offeror's costs from the period, from the date of the expiry of the relevant period to the date of acceptance. So regardless of who made the offer, the claimant will be awarded costs to the relevant period expiry. And then you need to look at who made the offer in respect of what then happens with costs after that expiry to the date of acceptance. I should say that there is no presumption that those costs will be made on an indemnity basis because it's been accepted after the relevant period. Unaccepted offers then, what happens then? This is where we turn to look at CPR 3617. These are the cost consequences that are most likely, or are relevant rather, to us in the business and property courts. There are other sections, as I say, later on in Part 36, which flow from subsection 20 onwards in relation to personal injury, which, as I say, I haven't focused on. But I just want to point that out at this stage. So, where the claimant fails to obtain a judgment which is more advantageous than a defendant's Part 36 offer, we look to, that should say at the bottom, CPR 3617 subsection 3. The court must, unless unjust to do so, order that the defendant is entitled to sorry, that should be, yes, the defendant is entitled to costs, including any recoverable pre-action costs from the date the relevant period expired, and interest on those costs. So when the court is establishing what is more advantageous, in terms of a monetary value, they will look at did the claimant receive more or less than the Part 36 offer. Interest on those costs should not be awarded at more than the commercial rate, which at the moment is considerably low. So won't be recovering much on those. And the costs are usually awarded on the standard basis. The court does have the discretion to consider indemnity basis costs, and they will be looking at circumstances such as, was it unreasonable for the claimant to reject the defendant's offer? Subsection B is in respect of judgment against the defendant is at least as advantageous to the claimant as the proposal contained in the claimant's Part 36 offer. And the consequences there, again, the court must consider whether it is unjust to do so, order that the claimant is entitled to interest on the whole or part of any sum of money awarded at a rate not exceeding 10% above base rate, the sum or all of the periods starting with the date on which the relevant period expired, costs, again including any recoverable pre-action costs on the indemnity basis from the date on which the relevant period expired, interest on those costs not exceeding 10% again, and then there are some certain percentage charges that the court will consider. So in considering the percentage charge, it will look at the sum awarded to the claimant by the courts, or in terms of if it's not made a monetary award, the prescribed percentages again are on the screen. Now, this idea is not to punish the defendant, allegedly, but to encourage the parties to consider reasonable offers and for the defendant to consider early on whether it is worth settling the matter. And this is where this idea of the carrot and stick method has come in. And there's an incentive to settle early because there's less consequences in terms of costs. For example, the indemnity basis doesn't come into question. The amounts on interested costs are much lower, and you're not getting to this rate of 10%. So Part 36, they do focus the mind somewhat, and if you do receive a Part 36, then it is worth considering in some detail with your client and actually going through the consequences of the acceptance or non-acceptance and what can happen. My top tips really, if you are thinking of making a Part 36 offer, or even if you receive a Part 36 offer, first thing to do is go to CPR 36.5 and have a look. Is this offer that you're making, or is this offer that you've received, compliant with those rules? If not, are you going to fall outside the scope of Part 36? If you've received the alleged Part 36 and you notice that it doesn't comply, do you let the other side know, or do you keep your powder dry and think, well, actually, you're not going to have the consequences of Part 36 in costs? That's a difficult one to answer. Is it, so wholly obvious that actually it's not a Part 36 offer? So you say something, or do you just keep it up, as I say, keep your powder dry and use it at trial and say, well, actually, no, this isn't a Part 36. And there's plenty of case law that would probably support you in that regard. So it's a consideration to make. If you're going to make a Part 36 offer, I cannot stress enough, don't mention costs. You don't need to. The sanctions are automatic. They flow. They're a very neat set of rules which have their own consequences. Judges and courts are very much on top of the rules. So you are likely to be told that, no, you haven't made a compliant Part 36 offer. But actually, the other point I probably should have started with is, if you get to that point of wanting to make an offer, actually consider at the outset, what type of offer do you want to make? Do you want to make a Calderbank offer, or do you want the consequences of Part 36 to flow? So that's a decision to make early on. You're very unlikely to just make a without prejudice offer, because, as I say, and as I said at the start of this webinar, it's unlikely to be able to be referred to the judge unless you made it very clear within the content of the document that in fact you want the judge to look at it in respect of costs. Now, that has been a bit of a whistle-stop tour of Part 36 this morning, and I appreciate I've crammed a lot into this session and run over slightly, for which I apologise. But if you do have any questions, then please do direct them to me at kwhite@st-phillips.com. I'll be happy to answer them. This webinar can be viewed again on the St Phillips Chambers YouTube channel, and it will no doubt be shared on LinkedIn and various social media platforms. There are a couple of questions coming in, but what I'll do, if you have any questions and you want to send them to me over this platform, you should have a button at the bottom which allows you to ask me a question. I will respond to you via email separately, or put a separate question and answer sheet with the webinar on LinkedIn, rather than hold you up for any longer this morning. I do hope that you found the session useful, and thank you very much for joining me this morning. I hope you enjoy the rest of your